Thursday, but your homework is to prepare for for the exam, which should have been prepared for today, so just think of it as you get bonus days. But in the meantime, let me do a quick review. Let's hit this one more time, shall we? Okay. But before I do, any questions with this new vocabulary? Please know that you've already seen, like, we spent almost seems like forever in chapter 2, does that make sense? Or 6 and 7, we've already finished one chapter in contracts. That's why we catch up to the syllabus, do you understand? So we're gonna be able to do a couple chapters at a stretch, and we do double up on the homework. And so your next test is like within 2 weeks. You see what I'm getting at? So I'm just giving you the transparency here that you're not caught like a deer in headlights going, what? I haven't even read chapter 11. It's like, well, there's your F. Everyone clear? So don't get behind is what I'm getting at. All right. I hope that you feel like you were gonna get an A today, okay? And if not, it's called getting polished to keep the A. Or for some of you, it's a lifeline that's giving you 2 more days to get it together. But the bottom line is, please know, as far as how you process the information, whether it's this first unit of instruction or contracts, it's all knowing the concept. Do you see what I'm saying? You've got to understand the concept to be able to apply it. So with chapter 2, remember, we want to go back to basics. In order for a plaintiff to actually file a lawsuit, certain foundational requirements have to be satisfied. Number 1, the plaintiff has to have standing to sue, which is there's a reason why you're filing the complaint in the first place. Because you've been injured, you've been harmed, you've been wronged, there's some damage done to you. Whatever words you want to use, the bottom line, what you're claiming is the defendant in some way directly, personally hurt you. Does that make sense? There was some reason why you were there. Harm comes, or hurt, or injury, or damage comes in one of 3 forms: physical, or financial, or emotional. That harm has to be in some way expressed in your complaint, where they know that it's directed at you, plaintiff, that if there was a contract, you had to be involved in it, in the center of it. If there's some dispute, and if there's a threat, it had to be present, it had to be imminent. Does that make sense? You've got to make sure that standing to sue is the reason why you're in the court of law. With that being stated, when you file that complaint in that particular court, you want to make sure that the court has jurisdiction over the defendant. There has to be some connectivity to why the court can make decisions over this defendant. And in order to automatically establish that authority to speak, which is jurisdiction over the defendant, you can have personal jurisdiction, which is if the defendant resides within the area that you filed a lawsuit in, or the cause of action happened within that territory, you've established personal jurisdiction over the defendant. If you filed a lawsuit based on real property and you filed a complaint where the real property is located, no matter where the defendant resides, you can automatically establish what we call property jurisdiction over the defendant, or in-rem jurisdiction over the defendant. If you don't have in-rem jurisdiction over the defendant because of the type of complaint it is, and you automatically do not have personal jurisdiction over the defendant, you may gain personal jurisdiction over the defendant if you're suing a corporate defendant who places their products into the stream of commerce in any of the areas you wish to file a lawsuit in. You've established that sufficiency of minimum context to establish personal jurisdiction over the defendant. However, if you don't have any of those scenarios, but you still want to sue in the particular place of your choice, plaintiff, you have to exercise your rights under the federal long-arm statute, which allows you to bring to the court's attention however few or many contacts you can ascertain that out-of-area defendant has with the territory you wish to sue in. If the court decides that those contacts are sufficient minimum contacts, you've established personal jurisdiction over the defendant in this way. If not, go to where the cause of action happened or where the defendant resides. Okay. Now, once you've established the court has jurisdiction over the defendant, you want to make sure that they know what they're talking about. Do they have jurisdiction over the subject matter? If your complaint is a general subject matter, file that particular complaint in the courts that hear those general subject matters. If it is one of a limited or specialized subject matters, make sure you file it in the courtrooms that hear those limited or specialized subject matters. Remember, plaintiff, if you have standing to sue, the court has jurisdiction over the defendant as well as the subject matter. The defendant still may oppose the particular location or venue of where they are because they are going to believe they have, maybe there's some reason why they're not going to have a right to a fair and speedy trial. maybe there's some adverse circumstances or media attention or what have you, they will bring that to the court's attention to make sure that they have the best location where they do have a right to a fair and speedy trial. And if the court agrees, they may move the particular location for trial to a more probative or equitable location to eliminate that type of prejudice. Got it? So when you take a look at those factors, as a plaintiff, you have a choice. If you file it in a state court, it's because they hear everything in the kitchen sink except federal questions. Or if you file it in a federal court, it's because it is a federal question because it has exclusive jurisdiction of federal questions only, or it has concurrent jurisdictions over United States constitutional matters, or maybe you want to satisfy federal subject matter jurisdiction because you have diversity of citizenship, which means the plaintiff and defendant are residents of different states and the aggregate amount that the plaintiff is suing for is more than $75,000. So either way, get into your situation, whichever court you want. If you're in state court, remember, the judges in state court are elected by we the people. And how does it work? The minute you file your lawsuit in the state trial court and decisions rendered, that court has original jurisdiction over your matter. You have the opportunity to appeal if you want to, but remember, typically appeals, which is a reviewing, it goes to the state appellate courts. It doesn't just automatically happen, and it's not granted because we're in civil court. What happens is, if you base your appeal on a proper question of law, typically it is granted. Because what you're claiming is the legal system itself somehow mismanaged or committed error in your processing of your particular case. However, if you file your appeal based on a question of fact, typically they're denied because what you're claiming is you don't like the way the jurors decided your case. Well, too bad. Unless no reasonable jury would have come up with that decision based on the evidence presented, you could get your particular complaint, with your appeal granted. Again, people are human, it goes from state trial court, appellate level to the state, appellate courts to the state Supreme Court, one in every state located at the capital of the state. Again, process for appeal is consistent. If you're in the federal court system, it starts with the U.S. district courts. Same process for appeals to get to the U.S. Circuit Court of Appeals. There's only 13 the District of Columbia. And then obviously the judicial branch, which is the U.S. Supreme Court, is the preceding national lawmaking body of the country, which precedes the state and federal court systems. But in order to get there, remember you submit a written cert if you're in court with a transcript, and 4 out of the 9 Supreme Court justices have to ratify or approve the writ in order to have your day before the U.S. Supreme Court. Otherwise, you do what you need to do to take care of your legal matter. In order to avoid the cost of litigation, you have other methods called alternative dispute resolution. You've got negotiation, speaking freely amongst yourselves. If you have an attorney, your attorney is your advocate and speaks on your behalf. You have mediation, neutral third party that tries to resolve the case. And again, they're voluntary. It can be done anytime before or during after a complaint's been filed. Again, it can be binding, which means you lose your right to trial. Non-binding, still very helpful to compromise and settle the matter. Then you have contract arbitrations. If your contract says go to arbitration, go. If you feel that it's been somehow oppressed in some way or unconscionable in some way, you can file a lawsuit. Okay, but the bottom line is, if you're involved in a lawsuit where the court mandates arbitration, that means you go before a neutral third party, typically a retired judge, 40 or 60 days before the trial date, and you can make it binding or non-binding. If it's non-binding, but you lose and decide to go to trial, you pay the other side's costs. Got it? Chapter 2. That's a big one. And then we have chapter 3. It's just vocabulary, but chapter 6. Again, look at all the elements to the torts. We just have a few minutes, but I will use them wisely. Remember, with your intentional torts, don't be fooled by that requisite necessary element for all the intentional torts, which is what? Intentional conduct by the defendant, which means whether you meant to do it or not, if the action still occurred or you set that defendant, the action in motion, that motion has a consequence. Whatever it is, that is intentional conduct for all the intentional torts. Got it? Take a look at all the torts and absorb the torts with the defenses. For example, with assault and battery, if there's a defense that applies, it justifies or it excuses the tort. Unlike the negligence. Negligence is not an intentional torts, but if you have the elements present for a duty of care that the defendant owes to the plaintiff, the breach of the duty with foreseeable cause to the type of harm suffered by the plaintiff, if you have all those elements present, negligence, it does exist. But then again, could potentially have viable defenses to that tort, but it doesn't automatically extinguish it. Does that make sense? Keep that in check, and then again, lastly, you have your strict liability, which is liability without fault, 3 areas: abnormally dangerous conditions, wild animals, and then the strict product liability. Remember, you're all the way through the chain of custody for those products.